Estate planning attorney Jason Lindamood here, and today we're going to talk about who a judge will select as your guardian should anything ever happen to you. Now, most of the time, whenever we talk about guardians in an estate planning context, we are generally referring to who we want to watch over our kids if something were to ever happen to you and your spouse. So today, we're instead going to talk about a different type of guardianship proceeding, one that would determine who would have say-so over your health care, over your finances, and over your well-being if something were to ever happen that rendered you physically or mentally incapable of taking care of yourself. And I'm going to lead with the punchline, then go in and backfill how we get there. But the bottom line is you need to have something in proper form, depending on which state you're in, depending on where you're watching this from, that is going to be legally sufficient to inform a judge simply who we want to be our guardian. Here's a worst case scenario. One of your loved ones has to file a guardianship proceeding, essentially a lawsuit, in order to pay legal fees. They have to go to hearings and they have to wait until a judge, till a court, makes a determination as to which person would be the appropriate guardian to act on your behalf. And it may not be the person that you would necessarily choose for that role yourself. So that's a lot of moving parts, and it's also something that we probably don't like, I suspect, to think about too much, but it's one of those things that really needs to be considered on the front end before something otherwise unthinkable were to happen to us and render us incapacitated on the back end. And lest us not forget, and let us remember, a last will and testament does not apply in this scenario. So if you have a will, that's great. We all need to at least have a will. I mean, at least have a will plus some other ancillary documents like powers of attorney, which we'll talk about in other videos. But a last will and testament does not apply in this particular scenario because you're still alive. So a will has no legal operative effect. As you know, and as you can imagine, a will only becomes operative once we die, once our heart stops beating. So we need another tool to address, again, this scenario. A couple things come to mind depending on, again, which state you're living in, depending on which jurisdiction you find yourself in. It could be a medical power of attorney that spells out your guardianship wishes within the confines of that document. Maybe where you live, it's called something like an advanced healthcare directive that, again, has language indicating the person or persons you would like appointed to serve as the guardian of your person if needed. In Texas, there's a specific document called a Declaration of Guardian that is statutorily codified. Back when we used to have the probate code here in Texas, it was in Section 679 of again, the previously used probate code. Then once it was subsumed by the estates code here in Texas back in 2015-ish, it's located in a different section. But nevertheless, this document is something you'll want to have available in case a guardianship proceeding ever needs to happen. The court will take your preferences into account, which can save a lot of potential family strife by everyone knowing what your wishes are, which is an important thing. Ostensibly, if you share, in proper form again, if you share with the court, with the judge, what your wishes are, that is going to be given great deference by the court. So it's very, very important for us to have something in place. In essence, the language in a declaration of guardian will say something along the lines of, I make this declaration of guardian to operate if the need for a guardian for me later arises. I designate fill in the blank to serve as guardian of my person. I designate fill in the blank to serve as guardian of my estate. And if any alternate guardian dies, does not qualify, or if they resign for whatever reason, the next person that I have named as the backup to my backup becomes my guardian. So that's normally the way it works. And I mentioned a will a moment ago, last will and testament. And if you have a trust set up rather than a will, if you have a revocable trust as sort of the nucleus of your estate planning portfolio, then a trust is a really effective way to skirt this issue of you becoming incapacitated, because there will be language in the trust contemplating that specific scenario and who would be your guardian, as well as a backup, and even, again, a backup to the backup, just in case. That will be the people responsible for taking care of both your person as well as your estate, should the case ever arise. So trusts are good for that. Revocable trusts are very good for that because they cover a little bit of everything. The guardian of you as a person, the guardian of your estate, and if you were to die, who your beneficiaries would be and how your property should be distributed to them according to your wishes. So if no trust is in place, it's wise to look at powers of attorney to go along with this declaration of guardian, as well as your will. And it's also wise to cover these bases in case the unforeseen happens, because like they say about insurance, hopefully you never have to use it, but if you need to, it's nice to know it's there, right? So better to be prepared than not be prepared. That's sort of the moral of today's video. Anyway, that's all I have for you today. Once again, this is estate planning attorney Jason Lindamood. If you thought that this video was helpful to you, and you feel like leaving a comment, or if you're in a position to hit a like button, that's always appreciated. If you think that somebody else might need to hear some of this information, share it with them. I'd appreciate that also. As always, thank you for your time, and I'll talk to you again soon.